Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 73 of the NCDWI Guy podcast. On today's episode, we are talking about restoration hearings. There is nothing more fulfilling as a DWI lawyer than helping your client at the DMV get their license restored following a DWI suspension. Literally, it is the best part of practicing law in my personal experience. Walking out of the DMV after the client has just been told that their license has been restored, generally after a multiple year suspension. I've seen clients in tears. I've had hugs with clients in this moment. It is one of the most joyful and fulfilling aspects of practicing DWI defense. Not all traffic and criminal DWI defense attorneys also handle DMV representation. If you don't handle DMV representation, consider doing so. It's an awesome part of the practice. Hopefully, this month's focus on DMV hearings will make the DMV seem a little bit less confusing, a little bit more of a workable place to practice, and you can apply what we are talking about here, as well as during last week's episode and for the rest of the month, into your practice so that you can start helping people either maintain or reacquire their driver's license. Obviously, the license impact of the DWI charges is one of the most just difficult collateral consequences to deal with. And so helping forecast for the client how they're going to go about getting their license back in the future, as well as dealing with ignition interlock violations and maintaining the license that is restored. That's a big part of being able to explain to your client how to successfully navigate a DWI. So again, I encourage anybody that does not do restoration hearings to consider doing that. I regularly have these. I know that other attorneys at the office regularly have these. If this is something that you are interested in learning more about, then please call us. We'd love to have you sit in on a hearing with us if we're able to do that. It's really an interesting thing to see. And again, one of the most joyful moments that I have with a client is helping them get their license restored. So without further ado, let us dive into the DWI restoration hearings. All right. So you get that call from a potential client about when they can get their license back. What is your first priority? It should be to run a driving history. The driving history is like the answer key. It's going to let you know whether or not your client is eligible for a hearing, when they're able to get their license back. Are they even currently revoked for a past DWI? Get the driving record ordered first. If you have somebody taking phone calls at your office, before they even put the potential client through to you, the driving record should be ordered, and you should have a chance to review it prior to any conversation with the potential client. If you're answering your own phone calls, then you need to put the client on hold for a few moments and get that information. Put the client on hold, get that information, and then move forward, then move on. So that is critical to making sure that you are advising your client appropriately about what their rights are related to the restoration hearing. So, how long is a person's license revoked? Well, in order to understand that, you have to look at 20-19. So We are going to kind of ignore the normal run-of-the-mill first offense DWI that results in a 1-year revocation of the license, where a person can probably, for at least some period of time, get a limited driving privilege. And instead, we are going to move on to a second or subsequent offense. So under 20-19D, when a person's license has been revoked for a DWI in the past, and then they receive a new charge, how long is that going to cause a revocation? Well, it might be for just the minimum of a year, or it might be for longer. When the person has another offense involving impaired driving for which he has been convicted, and that offense occurred within the 3 years immediately preceding the date of offense for which his license is being revoked now, the period of revocation is 4 years. So, quick example, person gets a DWI in 2016, is also convicted in 2016, gets a new DWI in 2021, is convicted of new DWI in 2021. 5 years between prior offense and new offense. Still looking at least level 2 sentencing because that prior DWI was within 7 years. But in terms of license revocation, only going to be looking at the minimum 1-year period of revocation if the 2016 and 2021 DWIs are the only 2 DWIs on the person's record. So the period, if it's within 3 years, let's say that first one is in 2019, convicted in 2019. Second is in 2021, convicted in 2021. The period of revocation in that situation is going to be 4 years. However, on that kind of a revocation under 20-19D, the DMV can conditionally restore the license after it has been revoked for at least 2 years. There's some conditions to that, but the conditional restoration can occur after 2 years. So the minimum period of suspension is 2 years. Maximum period of suspension under 20-19D is 4 years. All right, well, how about if we're talking about a person that has their third DWI revocation? So under 20-19E, a person that has 2 or more previous offenses involving impaired driving for which the person has been convicted, and the most recent offense occurred within 5 years immediately preceding the date of offense for which the person's license is being revoked, that results in a permanent revocation. So what that means is we've got a DWI currently that is causing revocation and 2 prior DWI convictions. If one of those 2 prior DWI convictions was within 5 years, then that's going to result in a permanent revocation. So again, if you've got a person that had a DWI in 2012, a DWI in 2013, both of those resulted in convictions, and now a DWI in 2021, how long is the revocation going to be? 1 year, because neither of the 2 priors was within 5 years and it wasn't a habitual DWI. There weren't 3 priors with it. There were not 3 priors within 10 years. So you change that up a little bit. Let's say we've got a client that's got a DWI conviction in 2012, DWI conviction in 2017, DWI conviction now in 2021, 2 priors, 2012, 2017, new one, 2021. That is going to result in a permanent revocation because one of the 2 priors was within 5 years. So the revocation is permanent. And what does that mean? Well, the person must have been had those 2 prior offenses, and one of the priors occurred within 5 years. So what does it mean for a person to be revoked permanently under 20-19E? Well, it means that the DMV can still conditionally restore the license after the person's license has been revoked for at least 3 years. And there's actually a slight exception to that that allows for a conditional restoration even under that section if somebody has been revoked for at least 2 years or 24 months. But there's some additional hoops to jump through, including 12 months of continuous alcohol monitoring preceding the restoration hearing. So it could be expensive to kind of go the 2-year fast track route to getting license back after that permanent revocation. But normally you're looking at a hearing after 3 years. So that's 20-19D, 20-19E. Now, how about 20-19E4? Well, if a person is revoked under 20-138.5D, which is a permanent revocation for a conviction of habitual impaired driving. So if a person's license is revoked under 20-138.5D, which is a permanent revocation based on a habitual DWI conviction, the division may conditionally restore the license of that person after it has been revoked for at least 10 years following the completion of any sentence imposed by the court. So that is the license revocation for a habitual impaired revocation. Moreover, if you've got a person that is revoked based on an offense that involves impaired driving and a fatality, so you've got a felony hit and run charge, felony serious injury or death charge. So you've got a charge that involves impaired driving and a fatality. The revocation is also permanent under 20-19I. 20-19I. However, again, permanent doesn't mean permanent. It didn't mean permanent when it was a third offense, doesn't mean permanent in the context of a habitual DWI, and it doesn't mean permanent here. Permanent in this particular situation means that the DMV may conditionally restore the license after it has been revoked for at least 5 years. So if it's impaired driving and a fatality, then unless one of the other sections applies to make that longer or to change things, then you're looking at a conditional restoration hearing after 5 years. So understand those timelines. Now, when do you begin to prep your client for a restoration hearing? Well, with clients that you're representing on a DWI, you start preparing them for that during the representation and immediately post-representation. So you're always helping them start to look towards getting their license back. Again, licensing in terms of being able to drive is a massive deal for most clients. This is like one of the biggest things that they are potentially lose or potentially looking forward to getting back. So don't waste the opportunity to help clients prepare to get their license back. So there are many things that a client can be doing during the actual DWI pending that could be helpful. So let's say that you have a client that is looking at potentially going into a sobriety court. Well, you can talk to them about the impact that that might have, not only in terms of the case that they're dealing with currently, but also in terms of down the road when they go to get their license back. If you have a client that is going to be on probation for a couple of years based on a level 2, level 1, level A1 offense, tell them that if they successfully complete probation, that's going to be helpful down the road in terms of being able to show the DMV officer that they've done what they needed to do. Many times on a DWI conviction, a judge will impose as a special condition of probation that the person abstain from alcohol during probation. Well, if they successfully complete probation and that was one of the conditions, you can later point that out to the DMV hearing officer that they had a 2-year period of basically monitored sobriety, regular drug screens that didn't show any amount of alcohol, that they complied with that special condition of probation that they abstain from alcohol. So you can use things that are part of the criminal sentence to both motivate your client to do well on probation or to adequately prepare for sentencing, but also you can use that again down the road at a DMV hearing. So constantly be trying to help your client see the long game. What am I doing now that is ultimately down the road going to be able to help prove that I should be given my license back? Help your client to see the long game. So again, when can you apply for a hearing? Well, you're going to have to look at the driving record, determine which revocation based on impaired driving applies under 20-19. And then from there, you can determine when the person is going to be eligible for a hearing. Generally, they can also call the DMV, probably sit on hold for a long period of time, but call the DMV and figure out for themselves when they are going to be eligible for a hearing. You may even have clients that call in and say, I already spoke with the DMV. They told me I'd be eligible for a hearing on June 1st, 2022. What should I be doing to get ready for that? They told me I would be eligible for a hearing on February the 1st of this year. So I'm already eligible for a hearing. I'm looking to get somebody involved to help me get that back. But they could contact the DMV if they haven't already to figure that out. So what does the hearing process look like? Well, the hearing process for restoration is a 2-part process. The first part of the process is to request a initial DWI interview. There is a $225 fee unless it is waived for an indigent client. $225 fee to request the driving while impaired interview. So that is what starts this license restoration process. The form that is used is the driver's license hearing request form. That is form HF-001. So the client would fill out that form, or you can fill that out for them, submit that to the DMV. And then if they are eligible for a hearing, and they filled out all of the appropriate boxes and information on the form, at that point, the DMV would set a initial interview. So that's the first part of the process. Now, what happens at that initial interview? Well, basically, if you have a client that lives in the state of North Carolina, that interview is a sit down with a DMV hearing officer, and all the DMV hearing officer is doing is trying to preliminarily see if there's anything that would make your client ineligible to have their license restored, at least in a very kind of preliminary way. But then more importantly, going through all of the paperwork that the client is going to have to then turn in before an actual restoration hearing can be scheduled. So they have to fill out a kind of driver questionnaire form that asks a bunch of questions about drinking history and other past information. They have to get a new assessment. So they have to get an assessment as part of that restoration hearing. They have to give names of people who are going to act as witnesses at the restoration hearing. And then, among other things, they also have to get a FBI background check and driving record checks for any state that they have lived in. I believe it's in the past 10 years. So basically, DMV is going to run their own driving record for North Carolina. But then if they've lived in any other state, they're going to have to get a driving record from that state in addition to the FBI background check that they're going to have to get as well. So at the initial hearing interview, the DMV hearing officer is sitting down, going over all of the paperwork that your client's going to have to fill out with them, explaining what they're going to have to do in order to move on to the next step, which we'll talk about in just a minute, which is the actual request for the restoration hearing itself. And then they'll basically say, get this paperwork back into me as soon as possible. If your client lives out of state and is trying to get privileges restored through North Carolina so that they can get a license in their home state, then typically this packet of information would be mailed to them, and there would actually be no sit down interview for the first part of the two-part hearing process for restoration. Now, in terms of this part one, the driving while impaired interview, the question that many clients ask me is, do you need to be present for that? And I have sat in with clients during this interview process at times in the past. However, there is really not much that your client is required to say at this hearing, nor do they have to kind of give any prepared or scripted or any type of answer that is going to be helpful at this point. So generally speaking, you're not going to provide a lot of value during the initial hearing interview. One thing I would suggest for anybody that is new at restoration hearings, I would absolutely go to the initial hearing interview so that you can hear the information that the DMV officer is passing along to your client so that you know what they're saying, and you're also going to learn stuff from that. So for a new attorney, I think it's definitely valuable. But if you've been to one or two of these things, after that, there really is not much new that is going to happen at a hearing interview. It's all one-sided, coming from the hearing officer to your client, explaining what the process for restoration looks like, but there is no legal issues really getting decided at that DWI interview. So that is part one of the two-part hearing process. After that interview, it's all up to your client. How quickly can they get all of that paperwork turned back into the DMV hearing officer so that you can move into part two? How quickly can they complete all of this paperwork so that you can move into part two? Once the first part is wrapped up, and then your client fills out all the paperwork, gets the FBI background check, all of the driving record requests done, and those are turned into the DMV hearing officer, they are then ready to apply for the second part of the restoration process, which is the driving while impaired restoration hearing. That has an additional fee of $425. So the first part of the DWI restoration hearing is $225 for the interview. The second part of the restoration process, which is the actual restoration hearing, the hearing fee for that second part is $425. Your client would use form HF-001 for both parts of the driver's license hearing request. All of the various types of hearing requests are listed on that form. So there's really only one form if you are making a hearing request, but both the first part and the second part of the restoration hearing process are listed on that same form. So you're actually submitting the same form to both request the DWI interview as well as the DWI restoration hearing itself. So now that that has been turned in, you basically are waiting for a response from the DMV to actually schedule the restoration hearing. Once a restoration hearing is set, then it's time to start preparing for the restoration hearing. So the main way that I prepare for a restoration hearing is to have a conversation with my client and a conversation with my client's witnesses that are going to appear at the hearing. I typically try to schedule this between 7 and 20 days prior to the hearing date, the scheduled hearing date. And the reason why is that you're normally getting a letter from the DMV several months in advance of the hearing. And if you call your client and you call the witnesses that far in advance, first of all, you're going to have to then call them back down the road to remind them of the hearing date, but you're also going to have to kind of go back through prepping them for the actual hearing. So you're going to have to kind of start the process over for prepping them for the hearing. So in terms of preparing my client for the hearing, here is kind of the outline in general terms of what I'm doing to prepare my client for the hearing. First of all, I am explaining the process of what is going to happen at the hearing. So I explain we are going to go into the DMV. You and then your 3 witnesses are all going to go into a room with the hearing officer. You're all going to go in separately. You will not be in the room when the witnesses are in the room. They will not be in the room when you're in the room with the hearing officer. One by one, the hearing officer is going to ask questions of each of you. I will have an opportunity to ask questions of each person, and then the person that's testifying is going to leave the hearing room and move on to the next person. So I explain what the process is. I explain that the hearing is recorded. I also want to go over the tone of how we are approaching this. So I always kind of use this language. We are going into the hearing officer's office with our tail tucked between our legs. We are not walking in to the DMV with a mindset that, we deserve to have the license reinstated, that we demand that the driver's license be reinstated. That's not the tone that we want to convey. We want to convey that we understand that driving is a privilege, not a right, that we have dealt with the consequences of being without a license, and we now take very seriously what a great privilege it is to have a license, but explaining that we are not going in there demanding anything. We're going in there very respectfully and humbly requesting for driving privileges to be restored. So I want to set that tone. I want to set that into the mindset of my client, that this is the appropriate way that we are going to communicate to the DMV and really kind of go through that with them. I also want to prepare my client for what questions they're likely to get from the hearing officer. So your client's going to be asked questions about the past DWIs that led up to this, and this is just kind of paraphrasing what the DMV hearing officer is going to ask. But, Mr. Jones, tell me a little bit about the DWIs that led to your license revocation. Tell me what happened. Tell me what was going on in your life at that time. So if the client remembers those, they should give, details about that. You should be prepared to talk through with them how they might want to communicate some of that information. If your client doesn't remember certain facts or things about the specifics of the prior DWI convictions, I always tell clients, and I also tell witnesses, if you don't remember, don't make something up. And obviously that's kind of, what the person should be doing, whether they're in the DMV giving testimony, they're in a courtroom giving testimony, but tell people it's okay to not know the answer to every question that they are asked, that it's understandable that somebody may not remember specifically all the facts and circumstances from a DWI conviction that occurred 10 years ago. They're not required to have a photographic memory. So just know that it's okay to not remember everything, and they don't have to feel like they need to know the answers. I think one of the major hiccup places in a restoration hearing is where a client actually does start making up information or trying to kind of reach back into the memory and then starts misstating something. The hearing officer has some sort of documentation from the past DWI that doesn't match up with your client's testimony. Now that kind of lack of credibility stems into all the other questions that are getting asked. So they're going to get asked about the past DWIs. They're also going to get asked about their current drinking history. So if it's a person with multiple offenses, are you still drinking? Are you using any type of prescription medications? Do you use any drugs? There's going to be questions for anybody that seems to admit that they had a drinking problem in the past. Are you actively engaged in AA? Are you actively engaged in some sort of rehabilitation program? So knowing that these questions are coming, again, is going to set your client up for success on the front end of things. If you know that somebody that has dealt with addiction issues in the past and maybe has put that into the questionnaire or has answered things to the DMV about that, they should be attending AA at the time that you go to the restoration hearing. That should be part of the project. If you're trying to show the DMV hearing officer that this is going to be addressed, is not going to be a problem in the future. The main thing that you're trying to convince the hearing officer of in a restoration hearing is that these multiple DWI convictions that occurred in the past, generally speaking, again, unless you have a DWI that also involved a fatality that's going to cause a lengthier period of license revocation, we're typically talking about a revocation that is based on multiple past convictions. So if you've got a client that has multiple past convictions, what you're trying to help the hearing officer understand is this is not likely to happen again in the future. Madam Hearing Officer, Mr. Hearing Officer, this is not likely to happen again moving forward. So how are we doing that? Well, we're showing all of the things that your client is doing currently to make sure that drinking and driving doesn't become a problem. And if you can show that your client is no longer consuming alcohol, is sober, and is working on maintaining their sobriety, that's going to make a hearing officer a lot more comfortable in that restoration. So they're going to get asked questions about their current drinking history. That is, your client's going to get asked these questions. They're also going to get asked questions about how they get, back and forth to work, to the grocery store, how they get around town, doctor's appointments, because again, the mortal sin for a hearing officer in these type of hearings is anything that would indicate that your client has been driving during the period of revocation. That's a big issue. And there have been times in the past where a client has called me on the phone. They've been like, look, my license has been revoked for 4 years. I'm trying to get my license back. And I ask, how are you getting around to work? What are you doing? Well, I just can't help it. I've got to drive. And, so I drive every day. Even if there's no past convictions, I normally do not want to get involved in a case like that, because it's going to basically be impossible to have your client testify at the hearing in a way that is either going to result in a restoration of their license. It's just going to be incredibly difficult to get a hearing officer to buy into that. So you basically put them in the situation where they're going to have to lie. And I always tell clients, we've got to be honest at the hearing about what you've been doing. But if we go into the hearing and you say that you have been driving, every day, I just don't see how this is going to be restored. And so I'm going to be honest with you. I don't think that there's much that I can do to help you through the restoration process. So, that's the thing that you really want to be cognizant of, is that the mortal sin of these hearings really is driving. And so you have to be able to prepare your client to explain very meticulously how it is that they are able to get from one place to the other without driving. Are they using an Uber? Are they using the bus? Do they have a moped? Do they have friends or family that are picking them up and taking them back and forth to work? Can you bring in receipts to show the amount that they're spending on Uber, that they've spent on a bus pass? The more that you can prove that they are not driving and that they are in fact following the DMV's revocation, the bigger chance that you have of having the client's license restored. So again, that's why I would generally advise people to stay clear of any client that calls about a restoration hearing that is telling you that they are driving regularly, because it's going to be very much an uphill battle. They're going to spend a lot of time, money, energy going through the hearing restoration process. And in my humble opinion, and maybe this isn't true in every single place across the state, maybe they're more forgiving hearing officers, but despite the fact that I feel like the 5 or so hearing officers that I have appeared in front of have actually been very friendly towards restoration in a situation where recent driving is a part of the equation, not likely to result in a restoration of the license. So I tell people that, I tell potential clients that on the phone on the front end of things, so they don't spend significant money in terms of my legal fees and time and energy going down the road towards restoration, only to be told, sorry, we can't restore the license. So again, got to have ability to kind of walk through that with the client during the consultation. In terms of questions for the witnesses, so each person that has a restoration hearing is required to bring at least 3 witnesses also to the hearing. They will come in one at a time. I'll get on the phone and I'll talk about the process with each one of the witnesses. Here's what's going to happen on September 22nd when we go to the DMV. Mr. Jones is going to go in first. The hearing officer is going to ask him questions. I'm going to ask him questions. And then you and the other 2 witnesses are going to come in one at a time and be asked questions. I explain the same thing to them as I explained to my client. We are going into this hearing with a humble attitude, respectfully requesting for the license to be returned. You get some family members or other people that are closely connected to your client that want to say, Jerry really deserves to have his license reinstated. I'm going to tell the DMV hearing officer that they need to give him his license back. And again, it's always about kind of communicating the right tone to the DMV officer, which is we are going in humbly requesting the hearing officer to reinstate the license. We are demanding nothing. We are making a big ask. We understand that it is a big ask. We understand there's a big responsibility to be able to drive again. And we are going to very confidently but humbly tell the hearing officer that we believe that we are ready to undertake that responsibility once again. But again, it's a privilege, not a right to drive. That should be the tone. So remind all of the witnesses of that just as much as you would remind your client of that. Same kind of questions are going to get asked by the witnesses as is going to get asked by the client, at least in a lot of ways. So I typically see each witness get asked, do you know why Mr. Jones's license was suspended? Meaning, do you have an understanding that this was related to DWIs? Do you know what was going on with the DWIs that happened in the past? Many of the witnesses that I have had testify didn't even know my client at the time that he got the DWIs. I have a lot of times people that are my client's sponsors or current employers, people in the community, friends that have been made since the time of these past DWIs. So a lot of times, these witnesses have zero knowledge of what led to the suspension to begin with, of the actual underlying DWI offenses themselves. And again, remind the witness, if you don't know something, don't pretend to know something. If you don't know the answer to one of the DMV hearing officer's questions, it's okay to say, I don't know the answer to that. I didn't know Mr. Jones at that time. I don't know anything about these prior DWI charges. It's okay. So you want to prepare your client for what they're going to get asked, but it doesn't mean they need to then go contact Mr. Jones and ask him about all of these past DWIs. I just say, if you don't know anything about the past DWIs, it's okay to say that you don't know. If you do know something about that, it's okay to communicate what you do know. The key to winning in a DMV hearing restoration is for the truth to come out. That's the key. If the truth comes out at a restoration hearing and you've done a good job vetting your client at the potential client stage of things before they actually sign on, and you've adequately prepared everybody, The truth is what you want to come out at the hearing, because everybody is going to be doing it easily, freely. This is not some scripted thing. It's really about just kind of understanding the process so that the witnesses, can speak well of your client, and your client can communicate what they are wanting from the hearing officer. So, going to get asked questions about the priority WIs. They're going to get asked questions about, is Mr. Jones drinking? Do you have occasion to see Mr. Jones out at night? Do you see him socially? Do you ever see him consume alcohol? If so, how much? When was the last time? How frequently are you out with this person at night? So again, there's no specific right or wrong answers to any of these questions. It's just about the witnesses knowing what the questions are going to look like. In terms of the last major topic is going to be centered around driving. So how does Mr. Jones get back and forth to work? How does Mr. Jones get his groceries? How does Mr. Jones get around town? How does Mr. Jones get his kids back and forth to school? These are the kind of questions that the hearing officer is going to ask. So each witness needs to know that they're going to get asked questions of, how do you see Mr. Jones getting back and forth, transporting himself from one place to another without driving? How does that happen? So each witness is going to get asked questions about that. One thing that I think is important, and I forgot to mention in terms of questions for your client, is generally the hearing officer is going to ask about, why is it important that their license be restored? Now, obviously, everybody has different reasons for wanting their license restored. And I mean, honestly, there's just a billion great reasons for that. But it is something that is very important to carefully think through how to answer that question. And it's not, to me, as though that is like the make it or break it deal for the DMV hearing officer, that they're only going to restore somebody that kind of like actually needs their license to get back and forth to, cancer appointments or something, truly significant and serious. I don't think that really is like the bright line test. I think it's more that if your client has thought through why their license is valuable and then expresses that to the hearing officer, says, I really am at a different stage in my life. I've got a great job for the first time in a long time. I have an opportunity for a promotion. If I have a license, I really want to be able to get back and forth to my kids' social activities. I want to be able to help out with my elderly parents. I want to be able to be more involved at the school that my kids are at and be able to volunteer there more and to be able to do carpooling for some of the other kids. If they can show how this burden is going to relieve other people in their community, whether that is family members or friends that have been giving them rides and not having to do that anymore, or being able to go out and actually take care of others, you're showing the positive impact that the hearing officer's decision to restore the license is going to have, not just on your client, but on the greater community. So have them prepared to answer that question in a way that looks on how not only this impacts your client's life, but how this is going to impact everybody around them. That same question would be typically also asked of the witnesses. So the witnesses are going to get asked a similar question. How do you think Mr. Jones would stand to benefit from having his license back? What kind of a difference is that going to make in his life? So have them prepared to answer that question as well. So again, about 7 to 20 days before the hearing, I schedule time with the client as well as with the client's witnesses so that they know how to answer those questions and be ready to respond to the hearing officer during the actual hearing. So day of hearing arrives, you get down to the DMV, get down there early. There is nothing worse than waiting at the last minute for a witness or a client to arrive. Unlike many district courts around the state, the DMV is no joke when it comes to time. So if it is 12:30, the hearing is supposed to start, right? And if it's scheduled for 12:30 and it is 12:29, you better be biting your fingernails, because 12:30 rolls around, somebody's probably getting called into a room. This is not something to tell people to come right at the, on the nose of 12:30. If it's supposed to start at 12:30, have your witnesses there by 11:45, 12 o'clock. Do not let somebody being late or delayed by traffic or whatever it might be cause an issue for your client getting their actual license back. This is a massive deal for your clients. Who do not let just kind of poor planning come into play. Make sure that everybody is there very early for the hearing, because that hearing is likely going to start on time when it comes to the DMV. So you walk into the DMV with your client, with the 3 witnesses. And again, typically the hearing officer is going to call your client back first. You go into the hearing officer's room, indicates that this is a recorded hearing, starts the recording, and then the hearing officer is going to start asking your client those questions. Hearing officer is going to ask your client those questions. Then you have the opportunity to ask questions or to present further information. Now, there have been times in the past when I have not asked my client or any of the witnesses much of anything. And I tell my client this ahead of time. I say, the value that I'm going to bring to you primarily is in preparation. I'm going to tell you what the hearing officer is going to ask. I'm going to tell your witnesses what to expect, how they can be prepared for the hearing, and then I'm going to be there to play damage control in case I need to be there. You are the one, Mr. Jones, that is kind of winning this hearing for yourself. I'm not arguing any special case law that is getting your license restored. This is very much a character witness hearing. That's what's happening, as we are doing a character witness hearing, and you are your own best weapon when it comes to this. If you are prepared and you bring the right tone to the hearing and you speak the truth, that's really where we're at. So I'll prepare my client for a few questions, but I will say one of the things that I will try to do is that if there are receipts from Uber or other taxi services that are used, then I will present those to the hearing officers. So, I've had clients that have had $6,000-$10,000 worth of receipts that we were able to show in terms of taxi fees, so that we can communicate to the hearing officer, again, this is a massive deal that my client's going to be able to save all this money if their license is restored. So I will go through any type of receipts or other information as to how that plays out. If I have information about some of the programs that my client has completed in the past, if they completed sobriety court, extensive outpatient treatment, continuous alcohol monitoring, I want to bring in the proof of that, because generally the questions by the hearing officer to your client are not going to get documentation regarding this, and nothing in the kind of interview packet is going to give that specific information to your to the hearing officer. So you want to be able to use that documentation as much as possible to be able to show why your client has addressed any addiction issues, what they're doing about that currently. So that's kind of the process in terms of the your client being called. Then each witness will be called in separately. Generally, there's not necessarily any specific order that has to be done in that route. So normally, what the hearing officer will do is just say, Mr. Jones, thank you for answering my questions. If you can just go out and get whoever you want to come in next, and we'll just start with the next person. So next person comes into the room. Hearing officer asks them question first. Then I get an opportunity to answer questions. And I would say specifically for most of the witnesses, I have very few questions. I'm not trying to get documentation out of them. I'm not trying to get any specific information out of them. If you prepped your witness well for what to expect at the hearing in terms of questions, then you're generally not going to have a lot of follow-up questions with any of the witnesses at the hearing. Again, prepare the witnesses for what has your client learned as a result of not having a license, and how would getting a license back help them in the future? Because that's going to be something that the hearing officer asks. But that is where I tell the witnesses, here is your opportunity to say good things about Mr. Jones. Talk to the hearing officer about what a good guy Mr. Jones is. Tell him what he does in the community. Tell him why being able to have a license would help him, why it would help his family, why it would help other people in the community. Go to bat. This is your, kind of opportunity to go to bat for Mr. Jones. So if that doesn't clearly come out through the questions of the direct questioning of the hearing officer, then when the hearing officer is done with their questions, then you can bring that out and really kind of make that character evidence shine through each of those three witnesses. But again, I generally ask very few questions of the witnesses themselves. So once all of that testimony is given by client and by the three witnesses, what's next? Well, typically at the end of all of the evidence, last witness testifies, the DMV hearing officer will then invite your client back into the room. All of the witnesses at this point will not be in the room. It will be you, the hearing officer, and your client. And the hearing officer at that point can ask your client additional questions. And I have that actually happen relatively frequently. Mr. Jones, did you know that your witness, Miss Smith, said that, she doesn't know exactly, how you get back and forth to work. Why is it that she doesn't know how you get back and forth to work? So they might ask follow-up questions based on what has come out of the testimony of the other witnesses, or there may be no further questions to your client. Again, there could be opportunity for further questioning of your client. But if there's no further questioning, then generally at that point, the hearing officer is going to give you, the attorney, the ability to present a closing. And so what you want to do is really, again, give a character closing. Talk about where your client was at the time that he got these DWI charges. All of the steps that he's taken to rectify his life since the time of those charges. How having a license back would help him in the future to improve himself, and how it would help others. Ease the burden on family members and friends, ease the financial burden that he or his family is experiencing, help others by giving your client the ability to be able to more easily take care of other people. So give that character closing and have a closing prepared, because you will typically be given that opportunity as to why your client's license should be restored. And I would say, in terms of the hearing itself, generally speaking, I think a lawyer earns their fee on a restoration hearing in preparation. So you're not earning your fee at the actual hearing. You're earning your fee in the preparation of your client and the witnesses for the hearing. But where you are earning your fee the day of the hearing is in your closing. So make sure that it is a passionate, well thought out, and good summary of the evidence that has come out closing for the hearing officer. After you give that closing, generally what happens is that the hearing officer will ask you and your client to step out of the hearing room so that they can think about their decision. And then basically If things go well, about 15 minutes later, you will get invited into the hearing room, and the hearing officer will begin going over a very lengthy conditional restoration form. Typically, a lot of paperwork follows having the license conditionally restored. It actually takes about 30 to 45 minutes to go through all of that conditional restoration paperwork from the DMV hearing officer with your client to go through all of that. Obviously, your client is ecstatic at that point. They could kind of care less how long it takes for all of this paperwork. Is like the only time when paperwork is like, who cares? This is the best thing that's ever happened. But again, unlike some other hearings where you might have a decision issued later, generally on a restoration hearing, the decision is going to get made the day of. If it doesn't get made the day of, that's probably honestly a bad sign in terms of the DMV deciding whether to restore the license. But fortunately for me, I think every restoration hearing that I've had up to this point has resulted in restoration, and that has really nothing to do with my skills or anything along that lines in terms of these type of hearings. The people that I've represented in restoration hearings, in my opinion, have been very deserving of getting their license back, have done a ton of mitigation efforts and kind of restoration efforts themselves in terms of putting themselves in a good position to get the license back. But you'll typically, again, step out of the hearing room, hearing officer will come back a few minutes later because they've been in the back working on the restoration paperwork, and they'll invite you and your client back in so that they can go through the restoration paperwork and what is going to be required in order for the plastic license to actually be reissued. So that is what we would expect in terms of the restoration process. Again, I encourage anybody that does not handle DMV restoration hearings to try to get their feet wet with these hearings, because again, if you regularly handle DWI cases in the courtroom, the magical moment for your client who has just had their license restored and getting to be a part of that is something that I feel every DWI lawyer should experience at some point. It really is like the best part of practicing. So for those out there that are in the grind in the courtroom, swinging at the evidence and helping clients through sentencing, more power to everybody that is on the front lines with us doing this. But I can just tell you from experience that there is really nothing more exhilarating and nothing more powerful and humbling than when you're able to help a client have their driving privileges restored. It is really a spectacular moment of practicing law. So with that, we will continue the conversation next week on DMV issues, discussing ignition interlock hearings. And I look forward to seeing you at that time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.